all rise. We would obey. Please be seated. We will as well.
Yes, Mr. Edwards.
Good afternoon, Your Honours. The topics that Madame Mathieu and I will be speaking about for the rest of today and possibly trickling into tomorrow cover broadly 5 subjects. I'm going to start by addressing you on matters of the credibility of some of the most important prosecution witnesses. Madame Mathieu will then respond to OTP submissions regarding crimes against humanity and specifically persecution. I then will cover the 3 main crime bases, crime sites in order: Kudumen, Bindisi, Mukja, and then Delej. We'll attempt to answer your honours questions at natural points as much as possible.
Can I just say, Mr. Edwards, it was pointed out at the end of Mr. Leitch's speech that he spoke at the rate of knots.
Yes.
And I see your fellow counsel nodding. Could you, I think, for the purposes of the French and Arabic interpreters, not go quite as fast, please? Yes. And in particular, when Mr. Leitch threw in, and that's the answer to question, whatever it was, I had to go back at the transcript and look at which question he said.
Well, yes. Miss Guillou is behind me, and she will kick me when that's required. Your Honour, there were some prosecution witnesses whose credibility was not challenged by the defence in this case. Other witnesses, there are a number of eyewitnesses who were cross-examined on the basis that they were likely mistaken about what they saw or heard, rather than on the basis that they were, on our case, deliberately lying. There were, however, a number of important prosecution witnesses who were cross-examined on the basis that they were not telling the truth, that they had come before Your Honours to lie about what they knew about Mr. Abd Al Rahman, for example, when they suggested that Mr. Abd Al Rahman was also known by the nickname Ali Kusheb, and about acts and conducts in 2003 and 2004. Questions of reliability, questions of credibility of OTP witnesses, that's dealt with in detail in our final brief. But I'll start by making a few introductory remarks, as much for Your Honours as for the public, if I may, about witness credibility, because it really is extremely important to this case. In criminal proceedings, every element supporting a charge must be proven by the prosecution. The prosecution bear the burden of proof. The defence need prove nothing. Obviously, when facing serious charges, it's important for the defence to at least attempt to carry out its investigations and, where possible, call rebuttal evidence. But as a matter of law, the defence do not need to do so. Mr. Abd Al Rahman, his defence, could have just sat here at the close of the prosecution case and told Your Honours that we had no intention of putting on a defence. It bears repeating and highlighting today, as one would in every trial, even a case tried by a bench of experienced, highly experienced judges, that the standard of proof is a high one. To convict a person accused of a criminal offence, you must be satisfied of his guilt beyond reasonable doubt. In some jurisdictions, it's expressed as a requirement that the trier of fact must be sure of an accused's guilt. This is the most fundamental principle of a criminal trial, and indeed it's enshrined in Article 66 of the Rome Statute. And when Your Honours do retire to consider your judgment in this case, we respectfully urge you to ensure that the burden and standard of proof remain at the forefront of Your Honours' minds. We're confident, of course, that it will be. Your Honours' chamber has a broad discretion in assessing matters of credibility and reliability of witness evidence. And you will give appropriate weight to that evidence individually and taken as a whole. Your Honours can rely on a myriad of relevant factors when considering questions of credibility and reliability, including corroboration, lack of corroboration, a witness's personal involvement in the events, when there are issues of a risk of self-incrimination, issues relating to possible bias or animus against an accused, and other motives for not telling the truth. You'll look at questions of consistency, contradiction, internally and with other witnesses' evidence. And you will bear in mind, to the extent you can, issues such as the witness's attitude during their testimony, their demeanour. All of these are matters that will impact on what weight you place on a witness's evidence. Item 31 in our list of authorities, I cite to the appeals judgment in the Gujolo case, 27th of February 2015, and I paraphrase what's contained at paragraph 168. The evidence of a witness in relation to whose credibility the trial chamber has some reservations may be relied upon to the extent that it is corroborated by other reliable evidence. However, there may be witnesses whose credibility is impugned to such an extent that he or she cannot be relied upon, even if other evidence appears to corroborate parts of his or her testimony. That's the end of the paraphrasing. Even an holistic approach of the entire evidence cannot erase a significant lack of honesty of some witnesses. There will be occasion when even approaching an holistic approach, it will not be possible to overcome issues regarding or issues of a witness's lack of credibility or reliability. And we say that is particularly important when it comes to witnesses that have come to be described broadly as the insider witnesses. There are also a number of witnesses, 7 I think, OTP witnesses, who we say must be approached with a great deal of caution because of lies that they told during other judicial proceedings, and here specifically I'm talking about asylum proceedings. And we say that that casts serious doubt on their overall credibility. Your Honours raised that as a question for us. It's question 24, and I will come on to it a bit later. Where witnesses' demonstrated lack of credibility really comes to the fore, Your Honour, it is in those situations where theirs is the only evidence going to a particular evidential point. And we will submit that where the most non-credible witnesses have provided uncorroborated evidence of an event or a feature of the OTP's case, Your Honour's chamber should reject that evidence. Now, let me make it clear. I'm not suggesting that corroboration is a legal requirement. It's not a requirement as a matter of law when evaluating any and all witnesses' evidence. In some domestic jurisdictions it is, but not before this court. But a trial chamber here may find, in the specific circumstances of a case, that corroboration of a particular witness's testimony, or part thereof, is needed for the trial chamber to be convinced of the evidence's reliability and credibility. And that point is made abundantly clear in the Kilolo appeals judgment, which is at item 35 of our list of authorities, paragraph 1084. So for the next few moments, I'll be making submissions on the credibility of the evidence of two key witnesses relating to Kudum and Bindisi, starting with P0878. This was a witness who was by no stretch of the imagination an impartial, neutral, objective witness, demonstrating that he had come to court to try his best to provide an honest account of what he saw and heard. Your Honours may recall the extent to which he demonstrated the most profound animosity towards Mr. Abd Al Rahman. And indeed, Your Honours may recall that lead counsel even had to raise a complaint before Your Honours about his, not just his animus, but his aggressive behaviour directed against the accused. It would be hard, we say, to think of a less measured, less moderate witness. And we say that his only objective in coming to court was to stick in the knife and to twist it. His objective was to divert attention away from himself and from his own obvious criminal responsibility in the events of Kudum and Bindisi. His evidence must be treated with great caution for two reasons. First, because he was clearly a guilty accomplice witness himself. Not, can I be clear, not an accomplice of Mr. Abd Al Rahman, but an accomplice to the murderous Janjaweed in Kudum and Bindisi. We're not saying that just because a witness is an accomplice witness, that his or her evidence should be disregarded. It's not per se unreliable, but it's always important to give careful consideration to the circumstances in which accomplice evidence has been given. And here I rely on, again, Kilolo and the Taganda appeals judgment at 35 and 37 on our list. Sorry, in Kilolo it's paragraphs 1531 and 1535. In Taganda, paragraph 734. But the feature that demonstrates beyond a shadow of a doubt that his evidence is so unreliable that it must be disregarded wholesale is the fact that he dishonestly denied bearing any criminal responsibility. He was an accomplice who dishonestly and frankly implausibly denied being an accomplice. And there are a number of features of his evidence that came from him and from him alone. It was that witness who memorably described the Janjaweed chasing women and men just like a dog chasing a rabbit or any wild animal chasing its prey. At paragraph 110 of its brief, the prosecution state that the government of Sudan provided food for the horses of the Janjaweed and Thoraya phones citing alone to witness 0878 as the source of that evidence. Similarly, when the OTP in their brief assert that Ali Kusheb was in command of the Agids and the Unda present at Kudumen Bindisi, and that P878 saw Ali Kusheb blow a whistle to summon 15 to 20 of his Ogada to give them orders, and saw him override their objections. This is at paragraph 154 of the prosecution brief. They cite to P0878 exclusively. It's P878 who is the only one to testify having heard Ali Kusheb make reference to a big celebration that would be put on in Garsila by Governor Jafar Abd Al Rahman, and that afterwards the new direction that we will take will be decided for us to carry out our program. Paragraph 178 of the OTP brief. And it's P0878 who is the sole source for the prosecution's reference that Ali Kusheb issued orders to the PDF officer Hasabala at paragraphs 193 and 356. Similarly, upon reaching Niala, the order given to soldiers to move forward, to move towards the village, the order to Hasabala to move behind him, sole source, 878, a very important witness for the prosecution, Your Honour, and yet untrustworthy, unreliable, incredible. Importantly for the issue of rape, I'm going to come on to rape a little later, but Your Honours will remember that in the evening, after the first day of the Kudumen Bindisi attack, Ali Kusheb was said to have congratulated the Agids under his command, and you'll recall the words that he said, they had taught the enemy a lesson the enemy will never forget. The evidence of Ali Kusheb scolding Hasabala for taking too long with his assigned task, paragraph 371 of the prosecution brief. And I mean, there are so many examples I could give. I'm not going to take up too much time, but at paragraph 353 of the prosecution brief, Ali Kusheb's words, "I will kill whoever I want and I leave whoever I want to leave." There's a sole source of that evidence. It's P878. At paragraph 438 of our brief, we deal with the evidence of P878, hearing, so it is said, Haroon's words at a public meeting. If you don't give back the property, you will be killed, you will be raped. This is relied upon in the prosecution's brief at paragraph 388. Crucially, P878 is the only witness to testify about those words. Why is that so important? Your Honours will recall that you relied fairly heavily. In any event, you relied on those words having been spoken in public and in the presence of Kusheb, when finding that he could be fixed with prior knowledge of the possibility of rape being committed in the future. P878, uncorroborated, alone. Similarly, paragraph 389 of the prosecution brief, 878 is the only witness to give evidence of a particular Janjaweed leader discussing the acts that they had committed against women that day, and speaking of his perception of women in those villages and how they were aggressed and raped. Our challenges to 878's evidence as an insider and an accomplice are set out in detail at paragraphs 117 to 120 of our brief. And we won't repeat them here. But he was not a credible witness. He was an untruthful witness. And all of that uncorroborated evidence, we would ask you to reject outright. Another of the important Kudum and Bindisi witnesses is P921. He also, utterly devoid of credibility, we say, like P878, an accomplice, a man with blood on his own hands. And we set out our challenges to his credibility at paragraphs 122 to 125 and at 386 to 398. Another witness whose interest in testifying before Your Honour's court was not to tell the truth, not to provide an honest and objective account of what he saw and heard. He testified principally to make money. We say that he baited his hook with a entirely false story about Ali Kusheb as being a leader of about Ali Kusheb as leader of the Janjaweed. He cast his line, and the OTP swallowed it. 921 knew full well when he made first contact with the OTP that there had been a warrant out for Mr. Abd Al Rahman under the nickname Kusheb. And his denials about that were so clumsy. They were unconvincing, but above all, dishonest. Given the very real doubts about the truthfulness of his evidence, Your Honours, what he says about his involvement, what he saw, what he heard of Ali Kusheb in the events of Kudum and Bindisi, must be treated with caution and with bucket loads of caution. Anything of which he is the sole witness to must be approached with a great deal of skepticism. He is not deserving of the slightest benefit of the doubt. Some examples. In the prosecution brief, he cited as the source for evidence of murders in Nearly, including the memorable evidence of people, including children, being thrown into burning houses. This is at paragraphs, for example, 274 and 366 of the prosecution brief. And then in Kudum, paragraph 275, allegedly seeing Ali Kusheb order his forces to shoot at 64 civilians in shackles, including women and young children, but also seeing Kusheb himself shooting. I pause simply to note that this evidence of Ali Kusheb ordering or shooting at people, including women, is quite inconsistent with those witnesses who state that Ali Kusheb directed that women not be killed. Regarding evidence of rape, and I want to stay in open session, Your Honour, so I'm going to be a little bit oblique, I'm afraid, but Your Honours will read in paragraph 332 about certain assistance that P921 says he provided. He's the only witness to talk about this. Very conveniently, you may think. It's not a feature of his evidence that could be easily corroborated, and of course, it wasn't. And we submit that he made it up, knowing how difficult it would be to challenge such uncorroborated evidence, whilst knowing just how self-servingly it put him in a good light. Why would he want to do that? To counterbalance the other evidence tending to demonstrate his own culpability for crimes in Qudum and Bindisi. Some of his evidence of the events in Qudum and Bindisi was corroborated by other witnesses. We accept that. But the main eyewitnesses of Ali Kusheb's purported involvement in the crimes there are all as untruthful as each other. The two witnesses I've spoken about, and also the witness with the code P1021, are all deeply flawed, deeply dishonest witnesses. And we set out in our brief, I'll give you the references in a moment, but the paragraphs in our brief addressing issues of the credibility of P1021 as well. All had strong motives to lie about Ali Kusheb's criminal responsibility. All had good reasons to want, desperately, to distance themselves from their own guilt, to distract by heaping the blame on the man already under arrest and so conveniently already in the frame. I turn from Qudum and Bindisi now to some of the witnesses whose evidence is not credible relating to the events in Mukhjar, and I'll start with P905, the witness who just happened to be absolutely everywhere, the witness who saw everything, always in the right place at the right time. Issues of his overall credibility were dealt with in our brief at 133 to 136. Your Honours may recall, in terms of his demeanour, just how markedly different he was under cross-examination to how open he was when being examined in chief by the friendly prosecution. I don't say that to disparage the prosecution at all, but in his own mind, they were on his side, he was on their side. You'll recall that this was the witness who was shown the video, the Aqsa Amsa video, the singing members of the Sunnis Armed Forces. And yet, despite that, even, he persisted in his untrue testimony that this was a slogan that was somehow unique to Ali Kusheb and the Janjaweed. We also address witness 905's credibility, or lack thereof, in paragraphs 456 to 464. The OTP attempt to explain his credibility issues away in their brief at paragraphs 187 and 232, explaining away his implausibilities and the incoherent features of his testimony. And they try to do that by reference to particular personal characteristics. I won't go into those now because I do want to stay in open session. They reference his protestations of his having been in fear at the time that he was with Ali Kusheb in Mukjar. But those explanations are utterly belied by the fact that when he had the opportunity to distance himself, having seen what he saw in Mukjar, to flee, he didn't. He stayed. And indeed, he remained in the company of criminals and came to give evidence about events in Delej. He too gave extremely incriminating evidence, wholly uncorroborated by other witnesses. In the OTP's brief at paragraph 188, the witness spoke of Kusheb issuing direct orders to an SAF staff sergeant. This is crucial evidence for the prosecution. They rely on it to demonstrate Kusheb's power to issue orders to the SAF. He was the only witness referred to, cited by the prosecution, testifying about the events mentioned in paragraph 25 of the OTP brief. Another example of how this is a man who just happened to be everywhere and saw everything. And he saw everything. He overheard everything. All incredibly convenient, we say. He was the only witness cited by the prosecution to give evidence of an incident when 5 captured men were brought before Ali Kusheb and were then met with the response, "Why did you bring them to me? I didn't say bring me anyone. I said execute the operation straight away." And thereafter they were taken away and killed. The order of Ali Kusheb telling his forces, whenever you encounter a man, you have to kill him. An important witness for the prosecution to establish Ali Kusheb's role, responsibility, power over his men to issue orders. But, once again, uncorroborated in respect of much of his testimony. Your Honours will recall there was one witness who asked to be given the opportunity to dress properly before being killed. This is relied on by the OTP at paragraph 433 and the LRV at paragraph 227 of their brief. The only witness, uncorroborated. And the only witness to testify about a particularly memorable and horrific account. And again, I want to stay in open session, so I will be oblique, but it's referred to in the OTP's brief at paragraphs 436, 454 and 55, 488. When Your Honours go back to read these paragraphs, you'll know exactly what I'm speaking about. But testified to by only this one discredited, deeply partial, and deeply hostile witness. We say that 905 was so transparently desperate to see someone, anyone, any Sudanese authority figure anyone associated with the tormentors of the Four population convicted and punished by this court. That person happens to be Mr. Abd Al Rahman. And so that's why he's 905's target. P 129 also gave evidence of the events at Mukhtar police station. A lot of his evidence also wholly uncorroborated. At paragraphs 234 and 237, the OTP refers to his evidence only in support of certain derogatory and insulting terms directed by Ali Kusheb towards detainees at Mukhtar. Insults such as sons of dogs, nujus, abids. A remarkable feature of P129's evidence is that he said he didn't actually know what abid meant. And we submit that calls into question the likelihood that he would have remembered the word in the first place years afterwards. And he was the only witness to speak of the insult, I don't know how it's pronounced, magus or magus, fire worshipper. Although we note the OTP doesn't rely on that evidence in their brief. Over the course of at least 2 days, at least 177 predominantly 4 males, including approximately 7 children between the ages of 8 to 12, were detained at Mukhtar police station. So asserts the OTP at paragraph 416 of their brief. It's P129's evidence of children as young as 8 years old that's relied upon and yet is uncorroborated by other witnesses. As is his evidence that Ali Kusheb severely injured a young boy aged 9 to 10 who was sitting near Umda Yahya Ahmad Zaruk by striking him on the head with a sharp end of his axe, paragraph 422. We submit that such a brutal, such a horrific assault on a young boy would be memorable. It would be one of the more memorable brutalities to occur at Mukhtar. It's remarkable, therefore, that P129 is the only witness to have spoken about it. An anodyne detail may have escaped the attention of some witnesses. It may be that the prosecution would say that with the passage of time, certain memories slip from, certain recollections slip from a witness's memory, and we understand that. But we say that an assault such as this on a child of that age just doesn't fall into that category. And we say that without corroboration, the trial chamber's approach should be a very cautious one. It's this witness, 129, who testifies to Kusheb striking Sheikh Abdallah Ahmad Hassan on his head with an axe, severely wounding him. Also striking Umda Muhammad Umar Ahmad Zaruk and Sheikh Ahmad Mohammed Barbai, all referred to at paragraph 420. He's the only witness cited by the OTP in their brief of these assaults. Uncorroborated, and therefore evidence that must be treated with the very greatest caution. P877 was a witness at Mukhtar. We provided written statement submissions on his reliability at paragraphs 490 to 493, 502, 503, and 520, and I'm not going to repeat those. There's one feature of his testimony covered by the OTP in their brief at paragraphs 471 to 72, which deal with 877's account of going to see Ali Kusheb at his pharmacy sometime after his release. We say that that is an account entirely lacking in any plausibility. We accept that it could be plausible that out of curiosity, out of a desire to know the truth, a person who had been mistreated would want to go to the pharmacy and see what he can see about the owner of the pharmacy, to see if the rumors were true, that his tormentor owned that pharmacy in Garcilla. What's wholly implausible, we say, is that a witness would have such scant regard for his own safety and security as to, go into the lion's den and to speak with Kusheb for 5 minutes. We say that is utterly implausible. The danger of being recognized would be too great. His actions were so foolhardy, so imprudent, so unnecessary that no credit can be given to his account. Uncorroborated, that evidence, of course. And the fact that this account is so implausible, so lacking in any credibility, creates doubts, even significant doubts, over the entirety of B877's evidence. And the doubts that exist, we submit, specifically relate to danger of contamination of other evidence, of other witnesses' accounts, given P877's particular standing in his community. I won't go into more detail, but his is evidence that must require, we say, corroboration. Where there is none, where he's the only witness to speak of specific features of the Mukhtar events, Your Honours should be very slow to accept his evidence. I'm aware of the time. I'm going to pass over some other points I had to make. P931, the final witness I want to discuss relating to Mukhtar crimes, another insider who demonstrated the clearest animus against Mr. Abd Al Rahman. We explain this at paragraphs 139 to 140 of our brief. And in addition, this is a witness who registered himself on a list of rebel volunteers, opposition volunteers. This is a convenient point to address Your Honour's question 25. You ask, some prosecution's witnesses are linked with rebel movement. How should the chamber take this into consideration? Let me briefly deal with that now, if I may.
Question was that you were saying the chamber should take it into consideration.
Yes.
And the question was how.
Yes, absolutely. At paragraph 173 of our brief, we deal with this. Your Honour, we refer to the case of Ptolemyr before the ICTY. I'm just going to cite from Ptolemyr. It's the trial judgment, paragraph 37. The testimony of persons involved in a bitter armed conflict is often coloured by experiences and attitudes arising from that conflict. The Chamber is aware of the general tendency of witnesses associated with a party to a conflict to give testimony that supports its perceived interest. Your Honour, here we have a situation where the rebels are a party to the conflict against the government of Sudan. They were the enemy of the government of Sudan, and the government of Sudan were their enemy. Each side fought the other. They killed each other. Inevitably, this creates animosity between the two sides. And we say that this must be particularly acutely the case when one side, the government of Sudan, acted, and we accept, in a particularly brutal way. The levels of animosity must be inevitably high. And there will then be a natural inclination, we say. It's really just a question of human nature. For a witness to provide evidence that places the enemy in as negative a light as possible, and to place the side that they're on in as positive a light as possible. And really, it just stands to reason, we suggest, that it's a relevant factor for Your Honours to take into account, because it can impugn their objectivity and therefore impact their credibility. It's really nothing more complicated than that. Passing now to witnesses of the alleged crimes. There's witness P643, a witness associated with a political party, and an important witness going to the issue of Abd Al Rahman identifying as Ali Kusheb. The prosecution deal with or cite to P643 in paragraphs 12 to 15. Mr. Lauchi will cover this in much more detail tomorrow. We address 643's credibility at paragraphs 142 to 144 of our brief, but I mention him here to recall that he had a close association with another troublesome, incredible witness in P878. His association with 878, hugely hostile, dishonest, we say significantly taints his own evidence. You'll recall that he gave his opinion at one point as to why it is that Ali Kusheb was appointed as Agid al-Oghada, because as a retired army officer, he had a good command of warfare. Paragraph 138 of the prosecution brief. He's the only witness to give that evidence, as cited by the OTP. And I'd also invite Your Honours to look at footnote 498 in the prosecution's brief, citing to transcript 58. I was going to read it out, but I won't do. There's no evidence that Abd Al Rahman had any experience of command in warfare. That's the important point. It's experience as being in a position of command, combat command. He was, for the majority of his time in the army, a medical assistant, a nurse. That is all. P643's ability and willingness to engage in the most wild speculation, untroubled by the lack of any facts, demonstrates that Your Honours must be extremely cautious before attaching any weight to his evidence. And in the same vein, really, 643, his evidence was enormously founded on hearsay, and sometimes hearsay at multiple removes. At paragraph 556, the OTP of the OTP's brief, they address what he heard about Genef's arrest and death, what he heard later on, paragraph 608 of the OTP's brief, what he heard about the deaths of Unda Kindiri and Unda Kamis. Elsewhere in the OTP's brief, what he heard about killings in Delej, what he heard of a report made about those killings. Your Honour, we urge you and your colleagues to be extremely cautious about what he says when reporting hearsay at one or more than one remove, because we say that he's a witness prepared to speculate, that he's an unreliable narrator. P994 was an inside witness to the Delej crimes. We say he was not credible. I'd refer Your Honours to paragraphs 566 and 568 and paragraphs 151 to 153. There was, this was yet another witness who demonstrated a striking difference between his willingness to provide an account when examined by the prosecution and his evasive demeanour under cross-examination. His cross-examination turned into an avalanche of I don't knows. Blood from a stone, that witness. And Your Honours may very well conclude that he was not, in the circumstances, an objective, disinterested witness whose motivation was to come and to do his best to tell the truth. He's the only witness to have overheard, or to claim to have overheard Ali Kusheb say to Unda Kindiri, whilst detained at Delej, "This is your last day on earth. Get ready for the doomsday." Paragraph 543 of the brief, and in fact, a memorable enough piece of evidence that was mentioned yesterday during the prosecution submissions. He's the only he's the only witness cited to by the OTP at paragraph 551 of their brief to have heard Ali Kusheb say to Genef, "Do you recognize me?" And Genef allegedly replying, "Yes, you're Ali." The source is cited at footnote 1788. Do not in any event support that assertion, we say, and we'd invite you to look at that site carefully. The last witness I want to talk about before handing over is P883. Our credibility submissions on him, including contradictions and inconsistencies, are in our brief, starting at paragraphs 145 to 148, 458 to 460, and 569 to 574. He is heavily relied upon by the prosecution in regard to the Delej crimes, but you'll recall that he simply wasn't present. His purported knowledge of Delej comes from other sources. And yet that didn't stop him being relied upon to give a great deal of uncorroborated evidence of background. And the OTP clearly believe that he's an important witness because they rely on him heavily in their brief. For example, paragraph 169, relating to a delegation of high-ranking officers visiting Delej. applauding the role that Ali Khrushchev was playing, the fact that he mobilized the Janjaweed. This is a witness who recalled an incident at a particular location, observing Ali Khrushchev handing his Thuraya satellite phone to a colleague, and that act created a great deal of annoyance, because that latter person's commander was being put through to him by Abd Al Rahman. The arrest, detention and release of Umda Kindiri, Kamis and Jenef, and the arrest and detention of Umda Suleiman, paragraph 522, citing only to this witness. P883 was the only witness to suggest that Ali Khrushchev killed Jenef at an execution site near the horrors of Soja, rather than in or near the police station. The only witness to testify that the Delej operation was not under the direct command and supervision of the SAF. Paragraph 657 of the prosecution brief, explaining that the decision to carry out an operation in a village or area was made by the SAF, but that the operation itself was then carried out by the militia or Janjaweed. Uncorroborated. And the only witness cited by the OTP, paragraph 578, of the reburial of persons outside of Delej several months after the killings. So we have made very full written submissions on P883's lack of credibility in our brief, but in sum, a witness remarkable for just how much of his testimony is both indirect hearsay evidence and is wholly uncorroborated. Can I just turn my back for a moment? Your Honour, we have fairly full submissions on the issue of asylum, and we've prepared a PowerPoint. But with Your Honour's, it's ready. But with Your Honour's leave, it may make sense to deal with it tomorrow, if we may.
That's fine. That's one of our questions, right?
Yes. It is. It's
The relevance of the asylum.
25.
Well, as I have said about 4 times now, but I repeat, anything that comes from a judge's question, only if you feel you have sufficient time to deal with it on top of what you want to deal with, need you do so, we will deal with them all at the end.
Yes, we're grateful. And can I say that I'm sure I speak for the prosecution as well. Your questions have been incredibly helpful, because it's always useful for a party to know where the jury, where the judges are coming from, what they're thinking of. So we found it an incredibly useful exercise.
Well, thank you very much. The reason is from my own previous experience as counsel of having the judges suddenly spring questions on you and having to ask for an adjournment and come back the next day.
Yes.
All right. Yes, that's fine.
Even worse is a bench that sits stony cold silent and without giving any indication of what they're thinking. So we're grateful.
Right. Yes.
Actually, I think that yes, I'm going to deal with other matters tomorrow, I think. You ready to? Yeah, this is a convenient and I can even say natural moment to hand over to Madame Matteo.
Yes. I think this is the first time we've actually heard from her.
Madame la Présidente, Mesdames les juges, j'adresserai seulement la question des crimes contre l'humanité
Right.
en
Okay,
évoquant...
okay, whoa.
Oui,
Miss Mateo, you will have to slow down. You must have seen the messages when Mr. Lauchi was speaking.
yes,
The interpreters couldn't keep up.
sure.
So try and keep it at a slowish pace.
J'adresserai seulement la question des crimes contre l'humanité en évoquant plus particulièrement certains aspects de la preuve quant à la connaissance et à la nature de la cible de la population civile, ainsi que la discrimination pour le crime de persécution. Votre Chambre devra déterminer si une attaque de grande ampleur était lancée contre une population civile au Darfour, Wadi Saleh, dans les localités de Moukjar en 2003, 2004, et en application dans la poursuite d'une politique d'État, telle qui est prévue à l'article 7.2a du statut. La thèse du bureau du procureur est que les actes incriminés s'inscrivaient dans le contexte de cette attaque à caractère généralisé ou systématique contre une population civile. Pour que l'accusé soit reconnu coupable, il faut la preuve de la connaissance de la circonstance que ces actions s'inscrivait dans le cadre global de cette attaque conçue par la politique d'État. Votre jurisprudence y fait référence. Je vous renvoie notamment au jugement Katanga sur ce point. La chambre de jugement, la chambre préliminaire Katanga dans la confirmation des charges. Et également le TPIR, le jugement Kaishema et Rodinana, paragraphes 133 à 134. Nous avons noté dans les numéros 29, 23 et 43 de notre liste de matériel. Le procureur allègue donc que la population civile était la cible de la politique d'État menée par les forces du gouvernement du Soudan en 2003 et 2004 avec le soutien des Janjaouides. Il infère l'objectif principal de l'attaque contre une population civile sur la base du nombre de victimes, la composition de la population et la façon dont les événements se seraient déroulés. C'est là au paragraphe 93 de son mémoire en clôture. À cette fin, il se base notamment sur nombre de localités qui ne font pas partie des charges. À chaque fois, dans les localités concernées directement par les charges, que ce soit à Koudoum, Bindissi, Moukjar et Délègue. Nous estimons que le procureur n'a pas apporté la preuve suffisante que M. Abd Al Rahman avait la position d'autorité ou de forte influence du seigneur leader Janjaweed, lui permettant d'interagir en connaissance dans la mise en œuvre de la politique d'État. La preuve au dossier nous a montré l'existence d'une hiérarchie, d'une organisation politique, militaire et administrative étatique clairement tracée. Toutefois, on glisse dans une certaine nébulosité lorsqu'il s'agit des liens de rattachement supposés existants entre l'accusé et le système de la politique mise en place par les forces armées globales du gouvernement du Soudan. Nous ne soutenons pas que le droit requiert que l'auteur soit membre officiel de l'appareil d'État. Mais la preuve versée ne suffit pas à conclure, au-delà de tout doute raisonnable, que M. Abd Al Rahman était un chef militaire lié à l'apparitus et à sa politique. Il n'a pas été prouvé qu'il était un chef seigneur d'une milice identifiée, organisée, affiliée à cette politique. Au paragraphe 398 de son mémoire en clôture, le procureur soutient qu'à Moukjar, M. Abd Al Rahman aurait donné des ordres au commandant de la police de Moukjar afin d'arrêter et d'enregistrer les hommes en provenance de Sindou. Il ne se fonde que sur le témoin P0905, dont nous contestons la crédibilité. Et Maître Edwards vous en a parlé il y a un instant. Au paragraphe 481 de son mémoire, le procureur nous dit aussi que le témoin P984 aurait entendu Ali Kouchaïb dire à Torchen, le commissionnaire de Moukjar, la plus haute autorité locale, qu'il ne recevait d'ordre que du ministre Haroun. Lors du même événement, où les deux conversaient toujours, Ali Kouchaïb lui aurait alors ordonné de lui remettre des détenus pour les conduire à Zelingay. Un doute plus que raisonnable existe sur la crédibilité de ce témoignage, selon lequel la plus haute autorité locale, le commissaire Torchen, se serait soumis à Ali Kouchaïb. On ne peut croire qu'eu égard à la position hiérarchique du commissaire Torchen, celui-ci aurait pu être subordonné à Ali Kouchaïb. Et le bureau du procureur assène pourtant l'existence de cette autorité supérieure d'Ali Kouchaïb, mais son origine n'a été ni identifiée ni prouvée. Même en assumant qu'une politique d'État soit prouvée, le lien de rattachement et de connaissance que M. Abd Al Rahman et ou Ali Kouchaïb avec sa mise en œuvre n'est pas établi. Nous avons exposé dans nos écritures l'insuffisance de preuves crédibles, fiables, trop souvent contradictoires, pour tirer la conclusion, au-delà de tout doute raisonnable, que la personne appelée Ali Kouchaïb était présente à diverses réunions et discours, notamment en présence d'Haroun, lors desquels la politique d'État d'attaque contre les fours aurait été exposée. Nous vous renvoyons nos paragraphes 677 à 685 de notre mémoire en clôture. À Moukjar et à Délègue plus précisément, la défense soutient que le procureur n'a pas rapporté la preuve suffisante de la connaissance que l'accusé avait du fait que la population civile était la cible principale de l'attaque conduite contre la population majoritairement four et qu'elle se rattachait à l'attaque généralisée ou systématique plus globale et à la politique de l'État. Cela est également pertinent pour ce qui est de la cible du plan criminel poursuivi et allégué en coaction directe pour Moukjar et Délègue. La preuve au dossier suggère que, plutôt que la population civile majoritairement four, en fait, ce sont les personnes suspectées d'être rebelles ou de soutenir la rébellion qui étaient ciblées. Dans ces localités, il s'agissait, du point de vue des auteurs des arrestations et mises en détention, de conduire une opération spécifique sur les ordres d'autorités locales, en particulier les comités locaux de sécurité, qui avaient identifié les suspects sur la base de l'information collectée par l'intelligence militaire. Nous vous renvoyons nos paragraphes 468, note de bas de page 1795 et 1796 de notre mémoire en clôture. Alors, la population civile désigne un collectif, par opposition à des civils pris individuellement. Le procureur doit prouver la qualité collective ciblée de la population dans ces localités. La Chambre de première instance dans l'affaire Bamba nous dit que, je cite, « L'accusation doit en fait établir que des civils ont été pris pour cible au cours de l'attaque en nombre ou d'une manière permettant de convaincre la Chambre que l'attaque visait la population civile et non pas un nombre limité d'individus particuliers. La population civile doit être la cible principale et non incidente de l'attaque. » Jugement de la Chambre de première instance, affaire Bamba, paragraphe 154. numéro 33 de notre liste de matériel, voir également le jugement Katanga, paragraphe 1104, numéro 29 de notre liste. Alors, rattacher nécessairement des arrestations ciblées à une campagne plus large contre la population civile reviendrait à ignorer l'objectif premier de ces arrestations et mises en détention. C'était la contre-insurrection, qui consistait à mettre un terme à la rébellion dans la région. Ces circonstances spécifiques doivent également se refléter dans l'évaluation de l'état d'esprit des auteurs des crimes que vous établirez. Cela en lien avec la mens rea requise de l'article 30 du statut. L'existence ou non d'une attaque généralisée ou systématique résultant d'une politique d'État dépendra de votre évaluation de la preuve au dossier. Les actes commis contre les personnes civiles et ou personnes hors de combat suspectées de lien avec la rébellion à Moukjar et à Délègue ne s'inscrivaient pas dans le cadre d'une telle politique. En tous les cas, on ne peut assumer que l'accusé, lui, en avait connaissance. Il ne faisait pas partie de l'appareil organisationnel global de quelque manière que ce soit. Les représentants légaux des victimes nous rappellent au paragraphe 216 de leur mémoire en clôture qu'au début de l'année 2004, la population de Moukjar s'est multipliée par l'arrivée de populations massives fuyant des attaques. Cette population serait passée de 7 000 à 41 216 personnes. Ainsi, il y aurait eu plus de 30 000 nouveaux arrivants à Moukjar. Les preuves nous montrent que les opérations d'arrestation qui ont lieu en février 2004, au point de contrôle situé à la périphérie de la ville par les forces du gouvernement soudanais, étaient ciblées en temps, en lieu, en nombre, par rapport à l'afflux massif de population. Il s'agissait de chercher et d'arrêter des rebelles potentiels susceptibles de se cacher parmi la population arrivante. Le témoin P0547 a déclaré que les rebelles étaient habillés en civil. Les auteurs des arrestations ciblées et mises en détention subséquentes cherchaient au moyen des listes dressées par les comités de sécurité sur la base d'informations collectées par l'intelligence militaire des éléments rebelles dissimulés au sein de la population arrivante. Voir le paragraphe 468 de notre mémoire, notamment les témoins P0990, P0129, P0922 et P0769. Ce ne sont ni l'ensemble des fours, ni l'ensemble des hommes fours qui ont été visés et arrêtés à Moukjar et à Délègue. Ces éléments sont également déterminants en ce qui concerne le crime de persécution et l'intention discriminatoire. En son paragraphe 230, le procureur se fonde sur le témoignage de P0675 pour affirmer qu'à Moukjar, les hommes arrêtés n'avaient pas de marque de port d'armes sur leurs épaules et n'étaient donc pas des rebelles. Les témoins P0675 et P0990, effectivement, nous disent que les auteurs des arrestations cherchaient des hommes, notamment avec des marques de port d'armes. Voir notre mémoire en clôture, paragraphe 468. Et nous ne soutenons pas que cette méthode de ciblage était la seule. Aussi, au paragraphe 232 de son mémoire en clôture, le procureur soutient que le témoin P0931 a été ciblé parce que four. Et pourtant, son témoignage nous montre qu'il s'était enregistré comme volontaire opposant voulant rejoindre la rébellion. Son ciblage ne semblait pas nécessairement ethnique, mais motivé par la recherche d'hommes susceptibles de soutenir militairement la rébellion. voir les paragraphes donc 168, note de bas de page 384 et paragraphe 139 de notre mémoire en clôture. Le procureur affirme en outre que des femmes et des enfants ont été emmenés au bureau de la municipalité de Mugjar Locality Building, pour y être détenus lors de ces arrestations. Paragraphes 230 et 250 de son mémoire. Mais ces faits et ces circonstances au bureau de la municipalité de Mugjar ne sont nullement évoqués dans la décision de confirmation des charges de la chambre préliminaire 2. Nulle part, il n'est question de détention de femmes et d'enfants et de la présence de M. Abd Al Rahman en ce lieu dans les charges telles que confirmées. Nous soutenons que la Chambre n'en est pas saisie. En outre, au paragraphe 408 de son mémoire en clôture, le procureur soutient que des policiers fours avaient également été arrêtés et ciblés car suspects de soutenir la rébellion. M. Abd Al Rahman aurait arrêté et confisqué les armes des membres fours de la police. Il se base sur un seul élément de preuve, le témoin P0877. D'autres témoins fours policiers, P0992, P0976, censés venir corroborer ces dires, n'ont finalement pas comparu. Aucun autre témoin détenu ou autre témoin présent à la station de police de Mugjar, tels que P0913, P0905, P0984, P0931, n'ont évoqué la présence de personnes en uniforme policier ou membres fours des forces de sécurité arrêtés et détenus. Bon, en réalité, ce sont les membres des forces de sécurité, y compris ceux appartenant à la tribu four, qui procédaient aux arrestations. Voir les paragraphes 468-480 de notre mémoire. Donc l'affirmation du procureur selon laquelle la conscription des hommes fours au sein de la police PPF leur offrait un caractère suspect est peu convaincante. Ce sont au contraire ceux qui refusaient de s'enrôler dans les forces gouvernementales de sécurité qui étaient suspectés. Si dans l'esprit des auteurs des arrestations et détentions, tous les hommes fours avaient été assimilés à des rebelles, les arrestations auraient été probablement en masse et auraient concerné en premier lieu les membres fours de la police PPF. Pour rappel, comme indiqué aux paragraphes 375 et 309 de notre mémoire en clôture, Jafar Abd Al Rahman, commissaire de Garcilla, chef du comité de sécurité, était four. 290 policiers fours ont rejoint les rangs de la police en février 2004. Paragraphe 445 de notre mémoire. Les témoins P0984 et P0913 ont témoigné que cet enrôlement reposait sur la peur d'être détenus en cas de refus. Si ceci peut aussi démontrer que seuls les fours qui refusaient de s'enrôler pouvaient être suspectés de soutien à la rébellion. Voir paragraphe 445 de notre mémoire, notamment le témoin P0913 sur la question. S'agissant de délègues, les preuves sur le déroulement des événements sont similaires. Elles montrent que des rebelles ou des personnes suspectées de soutenir la rébellion étaient la cible spécifique, car ils étaient sur des listes. Des points de contrôle ont été mis en place pour arrêter des personnes bien spécifiques, dont les noms et villes étaient sur des listes. Paragraphe 649, mémoire en clôture de la défense. Cette suspicion n'épargnait pas les Oumda et les Cheikhs, qui ont pu être arrêtés quand existaient des soupçons de leur soutien à la rébellion. Je vous renvoie au témoignage P083 de notre mémoire. Les décisions d'arrestation étaient notamment prises par le comité de sécurité de Garcilla, présidé par Jafar Abd Al Rahman. Il faut que je ralentisse, désolé. Le procureur donc soutient en outre que des jeunes garçons et personnes de plus de 60 ans ont également été ciblés. Le témoin P0907 est cité par le procureur dans son mémoire au soutien de cette allégation. Paragraphe 240, footnote 822. Mais celui-ci a également déclaré, ce même témoin, P0907, dont on vous a parlé le premier jour de ces closings. Celui-ci a également déclaré « Les personnes âgées et les enfants n'ont pas été conduits au poste de police, ils les ont relâchés. Ils m'ont conduit, moi ainsi que mon frère. » Et il a rajouté « Lorsque nous avons été emmenés au poste de police et que nous y sommes arrivés, les enfants et les personnes âgées ont été libérés. » Je vous renvoie au compte-rendu d'audience T084, la version française, page 32, pardon, T094, page 32, T096, version française, page 14. Le témoin P0651 avait 14-15 ans au moment des faits. Il vous a dit qu'il n'avait pas eu peur d'être arrêté car il détenait une carte montrant qu'il était collégien, qui le protégeait de toute arrestation parce qu'il n'était pas un adulte. Alors si certains témoins ont évoqué l'âge de personnes arrêtées appelées garçons, on doit garder à l'esprit qu'il est souvent difficile pour des témoins, après le nombre d'années passées, d'être en mesure d'évaluer l'âge de jeunes gens. Nous maintenons que la cible principale des arrestations n'était pas toute la population four masculine de ces localités et que la preuve contradictoire... Sorry.
The interpreters are begging you.
Oh, sorry. Nous maintenons que la cible principale des arrestations n'était pas toute la population fur masculine de ces localités. Que la preuve contradictoire et peu fiable ne permet pas de déterminer qu'Ali Kouchaïb ait participé aux arrestations et mis en détention à la station de police de Délègue le 5 mars 2004. Je ne sais pas s'il me reste quelques minutes, je peux continuer? Oui. Alors j'en viens au crime de persécution, lequel requiert une intention discriminatoire spécifique. Celui-ci englobe une série d'actes commis contre la population civile lorsque ceux-ci sont commis avec une intention discriminatoire spécifique des auteurs des crimes. L'auteur doit avoir ciblé une personne en raison de son appartenance à un groupe, une identité. Et ce ciblage doit être fondé sur des motifs énumérés. En l'occurrence, dans cette affaire, les motifs politiques, ethniques et celui du genre pour Moukjar et Délègue. La sévérité extrême des crimes ne démontre pas per se une intention discriminatoire spécifique. Le procureur soutient que les hommes fours de ces localités étaient perçus comme des supporters ou associés à des groupes armés rebelles, paragraphe 229 de son mémoire. Cette perception ne donne pas nécessairement un caractère discriminatoire politique à toute exaction. Il faut des preuves de l'intention spécifique du point de vue de l'auteur du crime, d'avoir commis son acte pour ce motif. Paragraphe 666 du mémoire en clôture de la défense. Le crime de persécution qui serait commis sur un groupe d'hommes fours ou assimilés à cette tribu fondé sur le motif du genre n'a pas de fondement dans cette affaire. Là encore, il faut des preuves de cette intention spécifique, prouver que les auteurs étaient animés de cette discrimination de genre en raison de la théorie du rôle social présumé attendu de tout homme four perçu comme ennemi en temps de guerre en 2003 et 2004 au Soudan. Si des femmes avaient été combattantes, ennemies dans cette guerre, il ne fait guère de doute qu'elles auraient été listées, arrêtées et détenues, car perçues comme rebelles par les auteurs de ces arrestations. Le témoin P20, cité au paragraphe 239 du mémoire de la défense, expose, lui, les formes de participation à la rébellion. Et surtout, aucune preuve d'actes discriminatoires, de violences sexuelles, d'humiliation, de mauvais traitements de quelque nature que ce soit, en raison du genre, ne ressort du dossier. Cet artifice ne tenant pas, le procureur a alors construit sa charge sur d'autres motifs discriminatoires, avec une intersectionnalité de motifs liés aux motifs politiques et ethniques. L'allégation de discrimination sur la base du genre dans ce cas d'espèce ne correspond nullement à la réalité des faits dans le contexte de la société soudanaise en 2003 et 2004. Et j'en ai fini avec ma représentation sur ces éléments constituels et la persécution. Je m'excuse du débit, de la vitesse. Voilà, et je vous en remercie.
I don't know ideas, but French is just that much faster than English. Yes, Mr. Edwards.
Your Honour, we've got 5 minutes.
Yeah, but I think, did you want to do something in 5 minutes?
I can briefly outline where I'm going next, if I may.
Yes, right.
Every minute counts, really.
Yes.
Yeah.
Well, I mean, the fact that we rise now, it doesn't affect your time.
Yeah. I'm in your honour's hands.
I think, because there's just one thing I want to ask you, and reflect overnight. We gave you leave for your client, the accused, to make an unsworn statement as part of your final addresses under Article 67(1)(h). The authorities say that's not evidence. So what I'd like you to reflect and address us on is, if it's not evidence, so what is it? Mr. Larch, I think I'll say tomorrow morning, because I know Judge Alipino Gonsu has got to go, but if you can tell me tomorrow morning how we're supposed to deal with it, then I'd be very grateful. Unless you can do it in one sentence.
Je peux le faire en une phrase.
Okay.
Monsieur Abd Al Rahman souhaite prendre la parole à la fin de son procès et nous relayons ce souhait de sa part. Mais bien évidemment, ça n'est pas de la preuve.
That really is not very helpful. Can you think about it?
Je ferai
and see
mieux
if you
demain.
can be more help tomorrow morning. Thank you. Yes, very well. We'll adjourn then, please, until 9:30 tomorrow morning. All right.
Oh, no, just very quickly, Your Honors, and I don't mean, sorry to slow you down. I just wondered if there's within the questions, anything in particular you would like us to focus on, because by my count, we went through 8 of them on the prosecution side, and whether there's anything in particular you think we should take a look at. Because what we tried to cover were 1, 3, 5, 6, 14, 18, 20, and 23. So we just wondered if you have any further direction. As Mr. Edwards said, we'd be happy to focus.
Yes. Did you deal with question 13?
No.
Yeah. I think that may be one of the more important. And 15. I'll say we did get a bit carried away. 26 and 28.
All right, thank you. We will try to be ready for everything, but we'll take a close look at those.
Okay, and I have a couple of extra questions. Sorry, I'm apologising to my colleague. Which, firstly, this is for the defence. If you're not running duress, as Mr. Nichols says, you haven't pleaded duress, so I'm assuming you're not running duress. No, and I see Mr. Light saying it. Then what's the relevance? Can you explain tomorrow, perhaps, what the relevance is of what's in your, for example, in your paragraph 261 about the death penalty and the disobeying of orders? Because it's a bit difficult to see what it goes to if it doesn't go to a form of duress. And the second is this, and it's really for the prosecution. Was there any evidence given as to what injuries Mr. Al Rahman suffered in the attack on him whenever it was, in 2013?
Yes, at least in the form of articles.
Yeah,
and
well, that's why, did it say where the injury was?
I would have to check one witness who was familiar, but there definitely were, broadly speaking, yes, what his injuries were.
Okay, all right. Well, if you could just remind us of it. Well, yes, thank you.
Thanks.
Yes, so again, we'll adjourn now till 9:30 tomorrow morning.
All rise. We will away.